Okay, I think we're going to be getting started here, and it is the top of the hour. And I want to thank everyone who has tuned in so far, and also thank the patience of those who came in early. My name is Frank Montero, and I a partner here at the law firm of Fletcher, Heald and Hildreth. I have with me my colleague Sarah Hinkle. And today we're going to be tackling the topic of political broadcasting, which should be very, very timely. And we have a absolutely stellar group of guests with us here. We have Bobby Baker and Gary Schoenman and Seema Nilsson, all from the FCC's political programming staff. And it is truly a pleasure to have them with us here today, and it is a real treat. I want just a few words about Fletcher Heald and our firm. Many of you know us already. We are a firm that's been representing broadcasters for almost a century now, and we have many resources available to broadcasters. Including our blog, CommLaw blog. You'll see a reference to it on our screens. Feel free to go into commlawblog.com, subscribe for free. There's a lot of really good information and articles on FCC law and FCC issues there. We also have a YouTube page, and this presentation will end up on our YouTube page. If you just go to YouTube and search Fletcher, Heald and Hildreth, you'll see a whole library of past webinars that we have on there on a very wide variety of topics. And I think you'll find them very useful. And as I mentioned earlier, this presentation will also go there and be archived there as well, and will also be available through the various state broadcast associations that we are presenting this with. Another item that I want to touch on before we get started is that any and all statements that are made or opinions that are expressed here by FCC staff are off the record and strictly their own. So this presentation is off the record. If there's media or press in the audience, just please keep note of that. And also we are going to be taking questions as we proceed, and we ask that you use the chat feature, not the Q&A feature, but the chat feature to put your questions. We just find that the chat feature is a lot easier to use, and we'll read them out loud. We already had one question here about objectionable material in an ad for a federal candidate, and we're going to be touching on that topic as we go through as well. And then lastly, I want to just give a shout out to all the various state broadcast associations that pool together to help this make possible, and especially to Luke Story and the Arkansas broadcasters who really pulled this all together. They did a fabulous job. If you're on and you're a broadcaster and you're not yet a member of your state broadcast association, I highly recommend that you join. They do fabulous work, and in fact, many of them are all going to be in Washington this week for State Leadership Conference, and I hope to see a lot of you for meetings with the FCC and with legislators on a variety of different issues that are important to broadcasters. So keep that in mind. And again, thank you to the state broadcast associations. Today, we're going to be covering a wide variety of different topics, including lowest unit rate, equal opportunities, what programs are exempt from equal opportunities, how to handle issue ads, record keeping, and also some very recent rule changes that just happened at the FCC no more than a couple of months ago. So we're going to be touching on that. And as Gary likes to hear me say, and more, but wait, there's more that we're going to be covering. So let's just dive right in. The first issue that we're going to be touching on is that of a legally qualified candidate, because it's basically the legally qualified candidate that gets the ball rolling here, that initiates a lot of the different requirements that are going to be triggered in the political broadcasting rules. And a question that comes up with many is, well, so what is a legally qualified candidate? How do we know when we're dealing with somebody who's legit? And there's various criteria that's thrown out there. They have to have announced an intention to run. They have to be qualified under state law. And keep that state law issue in mind, because that's really important. It's really going to be driven, and it can vary from state to state. They have to be qualified under state law to be on the ballot or to be a write-in. And that substantial showing as far as an intention to run is now includes the use of social media and the creation of a campaign website. That's a fairly new addition to the criteria that's on. It's part of this package of new political broadcasting requirements that were just added on very recently. Guys, do you guys want to shed a little light on some of these most recent developments that have happened at the FCC in terms of the substantial showing requirement and how it's been extended to social media and the like?
Sure, I can take that. There are two ways that you can be a legally qualified candidate. You can either be on the ballot, you can qualify to be on a ballot, or you can run as a write-in. And if you run as a write-in, you have to make a substantial showing. And what that essentially means is you have to engage in activities that we commonly associate with campaigning, and that's to separate the real candidates from the lunatics. Okay, and what we did recently is we expanded the list of what stations can consider when they look at a person and try to determine whether they've made that substantial showing. And we added two things to the list. The list is not an exclusive list. There can be other things that aren't mentioned, but we definitively said that stations can consider whether an individual has a campaign-related website or is engaging in social media of some kind related to the campaign. So those are two additional items on the list that a station can consider when they're looking at a write-in candidate. Of course, that only applies to write-ins.
Okay, well, great. That's very, very helpful, because sometimes there is some ambiguity, and we had questions a lot about, like, is this, I had years ago about somebody who wanted to run for office in the state, and they were literally serving time in jail. And so we had to research whether or not somebody serving time could be a legally qualified candidate. And it was a state issue there. With presidential candidates, like in primaries, they have to be qualified in the state, or for the national elections, they have to be qualified in 10 states. So again, check on what the requirements are with your local officials. So the next element is, has that qualified candidate engaged in a use? Is there a use going on here? And what is a use? What are people talking about when this question of use comes up? And basically what it is when the appearance or the identifiable voice of the candidate appears for 4 or more seconds, then you have a use. It's any positive appearance, there's a use. The appearance does not have to be controlled or approved by the candidate. And this is, this is important, because, this, like, way back when, people always used to talk about the Ronald Reagan movies, putting it on the air, that would be a use now. Or, if your on-air personality, if your DJ decides to run for office in your community, that suddenly becomes a use whenever he's on the air. And why is that important? Because the use triggers equal opportunities, and that's that's a pretty major issue, because in the case of, for example, if your DJ is on the air for a few hours every morning, now if that entire broadcast block is a use, then in theory, his opponents can now request equal time for equal amount, which he's not paying anything. So that's something to keep in mind. There are exemptions. The exemptions are bona fide newscasts, bona fide news interviews, bona fide documentaries. You'll hear the word bona fide a lot here, on the spot coverage of bona fide news interviews, because, basically if it's an infomercial that's done by the campaign, that's made to look like like an interview, and they buy time to put that infomercial on, that's not a bona fide interview. On the other hand, and I always ask you guys about this, like, we had there was a case a few years ago when Howard Stern had somebody on the air and was asking them questions, and they claimed that was a bona fide interview. A lot of people are like, Howard Stern, that's not that's not the CBS Nightly News, that's not Face the Nation, that can't qualify. But the FCC disagreed with that, didn't they, guys? Bobby, I think you're on mute. Bobby.
We did. It was an interesting case indeed, because at the very same time as this was happening, he had already in the recent past then been accused of being one of the great brokers of his time. And what they did, and what was the case that became compelling to us, is that they sent a list of, I think, maybe 500 interviews that he had done when he didn't do his shtick. And he actually did, sensible interviews with people, did a lot of governors of the state of New York, did a lot of public officials of all kinds, lots of people running for public office. And we decided, because we've been in the process for many, many years of expanding the universe of what these exemptions could cover. And we've decided that if someone can demonstrate that even if it's on occasion, that they do something that looks bona fide, that we will give them that exception, that exemption, for that purpose. Nothing else on Howard Stern's programming was considered to be part of the news, but to the extent he was doing these news interviews, which he did quite regularly, that's what we did. At the first blush, most of us thought it was ridiculous, but when we really started thinking about it, and over time, I think that's the right way to go, to give broadcasters more leeway in presenting programming in the fashion that they choose.
Right. Okay, well, thanks. That's great. The next thing we want to touch on is access by candidates. Now, this issue comes up a lot with us, where we have clients that ask us, this candidate wants to buy time for their ad. Do we need to run that time? Do we need to run that ad? Are we obligated? In fact, we had a question earlier on the chat room about what if the ad has objectionable content or that sort of thing. And I think in this instance, it divides up into two categories. There's how federal candidates are treated, and federal candidates have a right of reasonable access, which we're going to talk about in more detail in a minute. State and local candidates, their access is at the discretion of the station, and Sarah's going to talk about that a little later. But let's start first about how we need to treat, or how broadcasters need to treat, a request from a federal candidate. They are entitled to reasonable access during the entire campaign period, and what that means is that stations are not allowed to set just flat limits on amount or the type of spots that the candidates can run, right? You can't say, well, no spots that are against abortion, or no spots that favor pro-choice, nothing like that. But the stations do have some limited leeway to be able to reject unreasonable requests from candidates. And we're going to talk about that in a little bit a while as well. The federal candidates have to be offered prime time, program time. They may be excluded from news, but they cannot be excluded from any other category of programs. They do not have a right to dictate or demand access to any particular program or day part. And as for public stations and non-commercial stations, they are exempt from this reasonable access requirement from federal candidates. But remember, the public stations, they shouldn't be selling commercial time to any political candidates that are running. In terms of the federal access, there is a right for the stations to engage in a reasonable determination. There are things that they're allowed to consider. How much time was previously sold to the candidate? Is it going to be disruptive in programming? What's the possibility of equal opportunity? Like, what if there are 40 candidates? And likewise, the timing. What if they demand to buy your entire evening the night before the election? What are the disruptive effects of that? As far as the question that was posted and others, if there's objectionable material in that ad from the federal candidate guides, what do you think the station should do? What if they, there have been some instances where in political campaigns, they want to put on some pretty disturbing images, aborted fetuses, things like that, really over the top stuff. What's your advice on some of those issues?
Well, I'll do that. Well, let's go to the last thing that you talked about, the graphic imagery in these anti-abortion ads, which became quite prolific in the 90s. And many of them contain images of actual abortions. Others, and most of them had pictures of what were purported to be aborted fetuses sitting on the table, laying on a table, blood all over them, etc. And in a remarkable and disturbing possibility, most of these candidates wanted these ads to be on in the early morning hours in the preschool time period. They wanted children to see these ads. And what happened at the commission is that we got so many phone calls in a single instant from outraged parents about how is it possible that this kind of material could be on. And this was not a pro or anti-abortion thing. These were parents who were on both sides of the equation, who were so disturbed about it because their kids were essentially traumatized by it. And our phones would lock up. We always knew during a very short period of time until we started to take some action that that's what would happen. But the first proactive thing that we did at the commission was to allow them to use content-specific disclaimers before the ads. The following ads are going to be potentially disturbing to children and other vulnerable people. And we were giving them the ability to channel those ads from the morning into the later, not into the safe harbor, but I think we said at 10 o'clock at night and through until 6 o'clock in the morning. And that's what we did. So we allowed for the channeling. We allowed for the disclaimers. It was that particular decision was appealed to the District of Columbia Court of Appeals, and they shut us down on the idea that this material could be channeled. We, as a commission, had decided that the material was not indecent, as we understood that to be, but. So the court shut us down. They said that you cannot channel these ads merely because they have this kind of graphic imagery in them. They did allow the disclaimers, and the disclaimers did go forward. I don't know how much good they did, but they did inform people before these ads came on that what was about to happen may be disturbing. They were also permitted, certainly, to talk about this kind of programming in their news, to give another notification to people that they might not want their children watching TV from 7 to 9 o'clock in the morning, something like that.
Bobby, let me ask you another question. But isn't it in fact the case that these stations, if they are running a federal campaign ad because of the reasonable access requirement, because they have to, and it has, objectionable material, libelous material, even fraudulent material, that those stations may enjoy a certain degree of immunity because of the obligation that they have to air those?
Well, the word, I saw the text that came in the chat room, and the use of the word ass, A-double-S, I think was what he was asking about.
Right.
I don't think that's one of the words that on its face the commission considers to be potentially indecent. We've had ads that turned out to be one-offs, but they would be someone that was criticizing NRA started his ad with the F word, and it was the F word NRA, and there was a lot of action from Congress and other people about how could this be permitted. If it had been more than a one-off, this person bought one ad, did that, knew that he would get national attention by doing that. So if there's ever any of these things that some stations may consider to be objectionable, they have graphic violence in them, they have all kinds of things other than this kind of puritanical prohibition against certain kinds of words and activity. So anybody that has a question, they're scratching their head as to whether it's something that they can channel into the safe harbor, they should call us and we can help them work through it.
Or call your lawyer.
Or call your lawyer.
All right. Thank you, Bobby. I appreciate that. So now we're going to move on to the standard for state and local candidates who do not enjoy that level of reasonable access that the federal candidates get. And I'm going to hand it over to Sarah that's going to walk us through some of that.
Sure. As Frank said, unlike federal candidates, state and local candidates only have access to stations at the station's discretion. So that means they don't have a right to reasonable access really outside of the equal opportunities rule. Stations can take political ads or programming from some races and not others, for example. You can limit the number of ads and programming that you decide to accept. You can restrict certain day parts, but at the same time, you still have to make all of your discount classes available to state and local candidates. And at the same time, equal opportunities, lowest unit charge, and no censorship continue to apply. So once you accept a state and local ad, all of those regular rules ordinarily kick in. So speaking of equal opportunities, the Communications Act requires stations to give legally qualified candidates for federal office reasonable access to the station's facilities or to allow them to purchase reasonable amounts of time. This applies to candidates in the same race. So if a candidate had purchased an ad and they're running for the House of Representatives and a Senate candidate asks for equal opportunities, they don't have any right to that because it is not the same race. But they must request equal opportunities within 7 days of the opponent's use. So as Frank was saying before, the exemptions to what constitutes a use are really important when you're thinking about equal opportunities, because if it's not a use, then that person does not have any right to request equal opportunities. And it's also important to remember that 4-second rule, because if it's 4 seconds or longer, that is a non-exempt use. The next important item is the lowest unit charge. So this applies to all races, not just state and local. So we're back to including federal in these rules. This only applies though during those political windows that we discussed before. And the use has to be in connection with the campaign. Now, lowest unit charge only applies during those political windows, but even outside of the political windows, don't forget that equal opportunities and reasonable access still apply. So lowest unit charge may not at the time, but the other items do apply.
Let me ask you a question about that, because that last bullet point about a use must be in connection with a campaign, like, I guess what that is like, let's say a candidate owns a car dealership and he also runs ads for his car dealership. Well, those are not required to get lowest unit charge, because not, but I suppose that would constitute a use, no, right, guys?
You mean if he appeared as a car dealer in that, in
Yeah.
those ads? It would be a use.
Yeah, it would be
And-
no lowest
and-
unit
and-
charge.
But he's not entitled to lowest unit
Right,
charge because
exactly,
it's a
okay.
commercial advertisement.
Got
So.
it. Right.
Can I just go backwards just for 1 second? Someone asked about the news person within the news. I meant to clarify that even before this question came up. Being a presenter, and I think Gary touched on this, when being a presenter of the news does not exempt the appearance by the person who's presenting the news. So whether it's an anchorman or it's a sports reporter, whoever it is that's reporting during these various and sundry news programs, the interviewer on news interview programs, that does not exempt them from the equal time rule.
Right.
So,
Exactly.
and that's a very frequent question for us, where they have on-air people that have been doing lots of things at the station, doing on-air activities, and
Right.
they have to decide whether to take them off the air or not. They're not required to.
And if they're a DJ,
Practical
it's
matter.
easy, but if they're a news reporter, then, I can see where the confusion might arise.
That is, I mean, that part, and I always, when I see it, I think about that, because it does make it feel like even the people who are presenting the news are a part of the exemption, but they're not.
Right.
So moving on toward lowest unit charge. Lowest unit charge seems like it might be easy to calculate, but it really isn't always all that simple. It's the lowest rate charged for the same class of time, the same amount of time, for the same period of time that runs within that lowest unit charge window. The various classes could be fixed, preemptible, different classes of preemptible time could also be defined. And so you have to keep all of those things in mind when you're trying to calculate the lowest unit charge. And here are those windows again to remind you, lowest unit charge is only within those windows. Outside of those windows, they're not entitled to have the lowest unit charge. And with respect to this slide, this maxim that we have is really important, and I encourage everyone to go back to this slide and really review the maxim and keep it in mind when you're taking political ads and when it is an election year, and really try to take in all of the things that maxim says. I'm not going to read it to you here, but it is very important.
Yeah, if I can just jump in, when Gary, I think you had brought up in earlier conversation about some confusion sometimes about what the 45-day and 60-day requirement applies to. I mean, it applies to lowest unit charge, but how about things like use and equal opportunities?
Yeah, concepts like reasonable access for federal candidates and equal opportunities, which applies to all candidates, those entitlements span the entire length of the campaign. But lowest unit charge is only during those narrow defined windows preceding the primary elections, generally preceding the primary elections and preceding the general election.
Right. Okay. Yeah. So good to keep that in mind, because a lot of times people think, oh, well, there's no equal opportunities requirement because I'm outside the 45 or 60-day window, and that's just not the case. So.
Yeah. And in terms of lowest unit charge, and when we talk about discounts for candidates, generally they get the benefit of the frequency discounts. So, for example, if a station sells a commercial advertiser a certain amount of advertising, and if they buy in bulk, they get a discount. The candidate during those windows will get the benefit of that discount, even if the candidate buys just one spot.
Right.
So that's the benefit of lowest unit charge.
Right.
For candidates.
They get the individual unit.
Yes.
Right.
I just want to add one thing. I can't remember on your slides whether you talked about what happens outside those windows, which is the comparable rate period. Did I miss that?
We did
No.
not touch on that yet. If you
Oh,
want to go ahead,
okay.
Bobby.
Please.
Well, that's
go ahead.
important because it is sometimes a far longer period of time. And all that requires is that you sell in a way that's comparable to what you give your commercial advertisers. So in that instance, beyond these windows, if you want to buy frequency discounts and spend a lot of money buying spots, you have to buy the volume that a commercial advertiser would buy to get that privilege. So it's just what I look at it as sort of an anti-gouging provision. So you just have to treat them in the same way you would treat any commercial advertiser who came in off the street without those discount privileges that they get during the windows.
We have a question here that just came up. Can a station require a minimum buy for a local or state candidate?
What do you mean a minimum buy?
I
I
guess,
mean, limit them in terms of the number of spots they can
I
buy?
assume that that's what they mean, yes.
Yes,
Yeah.
you can.
Yeah, because there's a greater flexibility with the state, not with.
In other words, we
You
won't
can
sell
shut them,
to,
you
we won't
cannot
sell
sell
to
to a
you unless you
particular
buy
election.
10 spots.
I think that's what they mean.
Bobby, I'm not sure that I've come across that.
State and local? That's what he's talking about, right?
Requiring a minimum buy. I'm not sure that you
Oh,
can.
no. Oh, I had it in reverse. I thought you were saying, can they limit the number of spots to 5 or 10? They can't insist. A candidate doesn't have to buy more than one spot.
They can't require a minimum buy, but they can
That's
have a
correct.
maximum buy.
Yeah, I misunderstood. I'm sorry.
Yeah.
Okay.
That segues us back pretty well into package plans. As we were talking about with lowest unit charge, package plans, bonus spots, they're not considered a separate class. You have to keep those in mind when you're calculating the lowest unit charge. At the end of the day, it really ends up just being a volume discount. And I would say multi-year contracts are also calculated the same way with respect to lowest unit charge. You have to take into account the value of those spots during the same period of time, for the same amount of time, for the same class of time, whether it's a package plan or a multi-year contract. One kind of preemptible time that is also important for the lowest unit charge is that there could be 2 separate levels of preemptible time. It could be immediately preemptible or preemptible with notice. And if you have those separate levels of preemptible time with different rights, you're allowed to treat those levels as separate classes. But keep in mind that you have to have your lowest unit charge for each individual class of time. You also have to disclose the approximate likelihood of preemption based on which class you're purchasing if you have 2 separate types. So this will be an important one for broadcasters to go back to the next couple slides about how to calculate the lowest unit charge and what should I include, what should I not include. Here on our first slide, include every spot that you received consideration in exchange for. The value of packages, the value of multi-year contracts, the value of any bonus spots. All contracts that are in effect during that political window, which is the only time the lowest unit charge applies, right? And frequency discounts as well. And now what to exclude from the lowest unit charge. Spots for which no payment is received. And it's really important to distinguish that item from bonus spots because technically you don't receive any payment for a bonus spot either, but it is a separate thing. You could have a spot that you gave away for free for an entirely different reason that is not a bonus spot. And relatedly, during COVID-19, free time given away outside of any paid order, barter spots where you receive something non-monetary in exchange for the spot that you provide for someone, bonus spots for charitable organizations, and we have another list as well for what to exclude.
Let me jump in here because the item about free time during the COVID-19 pandemic, I remember when that was sort of adopted in the very, very early days of the pandemic, I guess in 2020. But it's still in there, right? It's still valid. There's no indication that the FCC is going to repeal that even though now some people are arguing that the pandemic may be receding. Is that correct?
So far.
That is correct. Oh, Bobby, if you want to.
Yeah, no, you can do it.
That is correct. The policy of allowing stations to give away time for free, so long as it's outside of of an already paid order, an executed order for time, that remains in existence. It was adopted early on in when COVID broke out in 2020,
Right.
and it remains in effect. It's in effect now. We have no idea when and if it will be lifted. And certainly if we do lift it, there'll be a public notice announcing that, but as of now, it is still in effect.
Right. Okay. Right. Wonderful.
Other items to exclude from the lowest unit charge are de minimis non-cash merchandising. That seems like a very long way to say free cat t-shirts, mugs, hats, lanyards, those kinds of things that are de minimis in value. And for web services, you would also exclude those. Treat those the same way you would a free hat or a free t-shirt. And of course, charges for producing the ad, line charges, remote production, all of those things should be excluded from the lowest unit charge. I don't know if you, Bobby and Gary, have anything else to add on lowest unit charge before we go to make goods in relation.
No, the only thing I have to add about lowest unit charge is if stations come away with anything from this, it's that stations generally will have multiple lowest unit charges for each class, each combination of a class, time, and day part. Stations sometimes think they need to have only one, but they will generally have multiple lowest unit charges.
Great.
Can I add one more thing?
Absolutely.
I think this is really a big one, just in terms of the situation that I think a lot of the radio people probably have for themselves. And that is in sale of clusters, there are now a lot of the big radio companies that they own sometimes 7 or 8 stations in a particular market, which is as much as you used to be able to have in the United States. But those clusters allow the individual stations to not include in their lowest unit charge what they get from that relationship. And that is only not for the clusters in radio. It's for any combination of 2 or more stations that get the same programming and have buyers who want to buy either the 2 stations or a much greater size network. Those stations do not need to consider, when someone comes directly to them, they don't have to consider that kind of compensation that they get from these network and cluster relationships. And frankly, it's from my way of thinking, because I've been watching this for so long, that has reduced substantially the amount of lowest unit charge activity that we once had, because there are so many different ways that to cut it. The other thing, of course, that's out there, and maybe some stations are not aware of it or it's too expensive, but there are softwares that are doing a lot of the work of really figuring out what the lowest unit charge is by literally just pushing a couple buttons and getting the answer to what is the lowest in this class and that class and so forth. I've never used it, I've never seen it, but I know that it's out there. So there's a number of reasons, I think, and I think people have gotten more sophisticated about what it is that they do with lowest unit charge. So, and of course, this thing that we did in this period with the COVID and allowing this, it's sort of artificial, but as long as they do provide this free time outside the scope of an actual paid contract, that's also not needed to be excluded. I think that will probably, unless there's another variant somewhere around the corner, and we finally get into a quiet period in terms of the virus, then I think the commission will probably take action and remove it. But I haven't heard anything about that at this moment in time, and hopefully for broadcasters it'll stay the picture for some time now.
Great, thank you.
I'm sorry to belabor it, but I have one more item about lowest unit charge. It is available only to candidate-sponsored ads. It is not available to issue advertisers who approach a
That
station.
comes up. Yep.
Very important.
Yeah.
Thanks, Gary. Thanks, Bobby. To wrap up on lowest unit charge, make goods are also potentially can affect a lowest unit charge. If the value is the same as other spots in the time period, then it doesn't have any effect on lowest unit charge. But if a make good it costs less than other spots in that time period, that make good could lower the lowest unit charge. So be careful when you are airing a make good. That's really important. And sometimes, you know, audience shortfalls, that happens. Make goods based on those, you got to disclose that you may have an audience shortfall. I mean, you just don't have any idea how many people are going to watch a specific ad until they actually watch the ad, as much prediction as we, you know, attempt to do. And also very important, if the make good is run before the election, if the station has provided time-sensitive make goods to commercial advertisers in that same class of time during the preceding year, then you must run that make good ad in a time-sensitive manner. And next, we're going to move on to political file and candidate ads, but we'll start first with BICRA, and that's the Bipartisan Campaign Reform Act. I think everybody has experienced BICRA, but might not know that they've experienced BICRA. You always hear the ad that says, I am so-and-so, and I have approved this message. Well, that's the stand by your ad provision from BICRA. There's no prescribed language in the statute itself. You don't have to say, I'm so-and-so and I approve this message. But you do have to identify yourself, and then you have to state that you do approve the communication. So, you know, that's the quickest way really to present that information to people. And it's important as well for TV ads to have that message on the TV with either the candidate themselves speaking the words and a video of them speaking the words, or a picture of the candidate and a very clear writing with, you know, appropriate contrast for the background that says that with a voiceover, if that's what you're going to do for your ad.
And this is for federal candidates.
Federal candidates.
And if they refuse to do it, then you can, you know, that you have grounds for denying low unit charge.
Exactly, exactly. And most candidates would very quickly comply and get the lowest unit charge. And now we're going to move on to Frank with the political file.
All right. Political file is an issue that has become, you know, I would venture to say white hot over the course of last year, in no small part because of the renewal cycle that radio and TV stations have been going through. This renewal cycle, especially on radio, has required stations to get their online public files up to date, and they're getting a first-hand education on how the FCC is able to review those public files remotely and verify whether all the information is in there. And nowhere has that been more true than with the political file. Anybody who's received a recent, one of the FCC's recent love notes in the form of a consent decree can probably concur with that. So for candidate ads, what has to go into the political file? You have to include the name of the candidate requesting, time, the details of who placed the order, contact information, the disposition of the request. And that's important because I get a lot of questions about people thinking that, well, if there was no sale, if the spot never ran, there was nothing to put in the public file. And that's not the case. You have to put information on the disposition of the request and the class of time that was offered and the like, and when it was aired, if it was aired, even if, you know, and put that information if a request comes in, even if there's no no running of the spot. With issue ads, now we're talking about programming that communicates a political matter of national importance. This comes up a lot as well. And likewise, you have to include a list of the officers and directors of the sponsors within the political file there as well. And you have some examples here of what might fall into that category. So in sum, with the political file, you have to keep the information for 2 years. You have to put that information in quickly after being contacted by the candidate. Another common misconception that I ran into during all the renewals that we worked on, and we did plenty, was stations saying, well, I did put the information in my political file. I put it in every quarter like I'm supposed to do. And I'm like, no. You're confusing this with the quarterly issues programs list, which is a completely different part of the online public file. With the political file, you are supposed to put that information in a very timely manner, which I think has largely been interpreted, right, guys, or SEMA, as what, roughly about 24 hours, 48 hours? What would your benchmark on that?
It's 1 business day.
1 business day. Okay, so there it is. So that's why you have to sort of keep on top of that, because again, when you put that information into your public file, it will timestamp that information, so they'll know when that material went in there in the first place. And then we suggest that you maintain a backup file of all this information as well.
Can I answer that top question in the chat room now?
Sure, absolutely. Take one there, Bob.
Is there a difference between a request for time and just a rate inquiry? There is. And if it's merely a request for availabilities or rates, that is not a request that needs to go into the file. It has to be a request for a firm schedule of time, so that the station can evaluate it and decide whether to accept it or to counteroffer, all the kind of negotiation that sometimes goes on. But so it has to be a firm order for something that's tangible in the way of a schedule.
Okay, good, excellent. This slide actually deals with something that's really more discretionary, but it's something that we suggest to our clients all the time, which is to prepare a type of a disclosure statement that you can hand to candidates or their campaigns when they come in the door, which would be sort of like basically a little summary that might include your classes of time, your lowest unit charge, make good policies, preemptible time policies, all of that information, so that you can hand it to the candidate. So there's no argument as to whether or not they were properly notified and that information was properly disclosed. But with the understanding that this disclosure statement is going to be a living document, right? Your lowest unit charge may evolve over time, so you may have to change it and update it, but at least you have it there. And we're not saying that you have to sit there and make them read it in front of you or that sort of thing, but just give them something that they can then walk away with, and that that they have that information. Going back to BICRA, which Sarah talked about a little bit earlier, the Bipartisan Campaign Reform Act. In addition to coming into play with regard to lowest unit charge and stand by your ad, an important part of it that Sarah touched on is basically it adds on to the already existing sponsorship ID requirements that stations are already obligated to do. I mean, if you are unfamiliar with what your station's sponsorship ID obligations are, obviously contact us, and we have information on that on our blog. But in addition to that standard sponsorship ID information that's applicable to commercial advertising or any paid advertising or any paid content on your on your station, you also have to have a language where if the federal candidate mentions an opponent, again, they have to be able to go on and identify themselves, stating that they authorize the ad. If it's television, you have to have the image of the candidate so doing. In radio, you want to have the candidate's voice, identifying her or himself, the office that they're seeking, and that they approve the ad. Likewise, BICRA comes into play with issue ads as well. And if it's content advocating the election or defeat of a federal candidate, they have to state that they authorized the content as well. Or if they didn't, if it was put on there by a third party or an issuer advertiser, again, you have to state who is actually paying the consideration for that content that goes on the air as part of this additional sponsorship identification requirement. And then last, before we go on to a question and answer period, is just a little something about payment procedures and payment policies. We get a lot of questions here about can I require a candidate to make a payment in advance? Do I have to give that candidate credit when I don't know who they are or that sort of thing? Basically, with federal candidates, and again, we have the situation where federal and state are treated slightly differently. With federal candidates, you can require payment in advance, but no more than 7 days in advance. For state and local races, you basically look to whatever your station's policies are with regard to commercial advertisers and the advance payment policies for regard to those. That's what's going to apply here. And as far as whether or not you are required to offer credit, this a basic, pretty easy rule of thumb here, which is basically you should offer credit if the candidate has an established credit relationship with the station, if the candidate assumes responsibility for the payment, and if the station would have given credit to a similarly situated commercial advertiser in a similar situation. So with that is the end of the content. And so we've got a lot of questions in our chat room here, and I want to try to open some of these up to see if we can take a look at them. And let's see if let's start from the bottom up. How does the FCC and stations determine what content is bona fide, since there is increasingly a lot of partisan content being broadcast? Guys, you guys want to, that's actually really a good question, because the line between, what is editorial content and what is just news gathering has become blurred at all. How does that impact whether or not something is exempt as a use?
That's a great one. That really is a great one. We're not the arbiters of truth and falsity in programming, so that even if we ourselves are watching something that we believe is untrue, we can't do anything about it. It is absolutely, the Communications Act itself has a prohibition against us censoring material. So, and of course, this line is getting harder and harder to define, because there is a lot of programming that is being described as news programming. There are channels which are being described as news channels, but we just are not in a position to be making decisions about that. We're literally prohibited from doing so. And as I said earlier, when we were talking about the expansive nature of what the exemptions mean, we've bent over backwards to make them expansive in terms of what can be considered bona fide. So we've made the line even harder to define in that regard.
It's pretty safe to say, though, obviously, that if they, if they pay to be on that show, if they, if
they pay to be on the show, then that's
clearly
not an exempt appearance, right?
Right. Okay.
That's an easy
one.
But I thought the question really was talking about what's generally happening, where there are outlets that are just they have a point of view in presenting the news.
Right. All right. Let me. I'll pick another one here. Let's see. Are there any limitations on online videos or social media advertising for candidates?
To date, I mean, in terms of anything that's out there in the streaming world, digital, we don't have any regulatory authority over it. And I don't think anyone else does.
Right. And I will actually add on to that, because there's an interesting little, where if you are, I mentioned earlier when we were talking about some of those sort of, offensive content ads that might, or might content can be libelous or have fraudulent content. And if they're put on the air for a federal candidate, there might be a certain amount of liability immunity. But if you are simulcasting your content over the internet, if you're streaming that content, well, guess what? On the internet, you are not exempt from libelous content or liability there, and you could be sued or come after for that.
I would also say the Federal Trade Commission has jurisdiction over unfair and other types of advertisements in that sense. So I would be careful not to run into any Federal Trade Commission issues if you're, producing libelous or fraudulent content. I'd be careful of the Federal Trade Commission. Though, if you have a specific question, contact your attorney.
I've got another one here I actually have it. It's from my buddy Armando Quintero, who I know up in Minnesota. If a state or federal candidate from our state was on a network program station aired, does the local station have to provide equal time if the opponent requests it?
Yes.
Yeah, I think so too. Yeah, I agree with that.
Yeah, I mean, if I can jump in here, if a candidate purchases time on a network, and that can be a national network or a regional network, and the candidate ad airs on multiple stations, an opposing candidate for the same office who requests equal opportunities can go to any one or all of those stations. So the requesting candidate who's seeking equal opportunities can cherry pick and go to an individual station and say, look, I heard my opponent's ad on your station. I want equal time on your station. I don't care about the other stations.
Yeah, but I think this is also about if they appear in programming. I mean, as another example of this, I guess the same issue. When Schwarzenegger was running for governor in California, and I think that maybe the first Terminator movie had come out, the airing of that movie, wherever it aired in the state of California, would have subjected the stations that carried it to free equal opportunity requests. So I'm guessing, because we never heard more about it, that the stations in California didn't run Terminator ads. I mean, Terminator movies, because of the tremendous amount of equal time that would generate.
I have another one here. This one actually may be for Seema, because Seema, you mentioned the 1 business day rule as far as uploading the information, and there was a question about, okay, where does it say specifically 1 business day? And then there's another question here that says, does the 1 business day upload rule for the public file apply to affidavits as well? In other words, the asker says, do we need to upload affidavits every day? Or can we wait until we run our monthly billing when we typically print affidavits? And I assume this is affidavits that the program actually ran.
Right. So our general policy on that, first of all, the 1 business day is not in the rule itself. It's how we've interpreted what's in the rule, which is as soon as possible. So reconciliation documents, copy, which is sometimes not provided at the time the request is made. Anything that comes in later than the request is not subject to that 1 business day requirement, but should be put into the file as soon as possible. So if the station, runs its invoices on a monthly basis, then that's when that would go in.
Okay, great. I know we're at the top of the hour, but we've been informed by our fearless leader, Luke Story of the Arkansas Broadcasters, that we have can take a little extra time because there's a lot of questions here. So maybe we might run a little bit long. I apologize, but this is good stuff here, and maybe run another 10 minutes or something like that to take a few more questions here. One that came up is there still a 7-day window for requesting equal access? I think we actually touched on that earlier, and the answer is yes. Is that right? It's 7 days?
Yes.
Right. But you don't have to reach out to the other candidates to, solicit a request. They have to come to you, right? They have to
Yeah, the notification in the file is all that we require, and they're not required. I assume probably some stations do touch base with opposing candidates to hopefully generate some equal opportunities and make more money.
Okay.
If I may jump in, I think that this question might be coming up because there's also there is a caveat to that, which is that if the station doesn't put the information, doesn't upload the record of that spot within, the 7 days, it's the later of the upload or the 7 days, because obviously opponents aren't going to be able to listen to or watch all the stations that may be running their opponents' ads.
We have another one here. For agency buys, how should a radio station handle lowest unit rate with regards to the 15% agency discount? Oh,
You mean the 15% discount or the 15% percentage that goes to the agency?
yeah, I think it's 15% that goes to the agency.
Well, candidates using agencies would be entitled to that particular rate, and if they come in and they're not using an agency, they walk into, and they're buying time on their own. And I assume there's a lot of small market instances of that, and candidates who do a lot of their own work and don't have consultants and agencies. So if they do that, then they're entitled to the net rate. So if somebody had bought a spot for $100 and $15 of that went to the agency that they were using, then the net rate would be 85. So if a candidate comes in without using an agency, they get the $85 cost. Okay. It's whatever is net to the station in the end.
Here's another one. Are the voices of the actual candidates required to be in the radio on-air advertising, or is the paid for by candidate sufficient? Is that sufficient, or do you need the actual voices of the actual candidate?
Well, the IDs are supposed to be 4 seconds, and if the voiceover on radio is in the actual voice of a candidate, not an actor, then doing that sponsorship ID is sufficient to be a use.
Okay.
Because it's supposed to be 4 seconds, and so it's pretty simple.
Okay. Here's another one. If a station offers a discounted rate to nonprofits or governmental entities, does that factor into lowest unit charge?
No.
Okay.
And it's only commercial advertising.
It's only, you only compare it to the commercial
right.
advertising. Okay.
And so government, lottery advertising in particular, which is government run, that doesn't it doesn't factor in the lowest unit charge. It has to be commercial advertising driven.
And that goes back to that maxim that was on that one slide. That should answer a lot of those questions about things like that. So definitely go back and review that.
Okay,
I have to say, my observation about the questions in this particular webinar they're terrific.
Yeah.
I mean, we sometimes get questions that are very rudimentary because to a lot of people, what we're talking about is kind of gobbledygook. But there's a lot of thoughtful stuff here that people are asking.
I do see a question that we get pretty often, and it has to do with NAB forms for uploading information.
Okay, yeah, Gary, good job.
To the political file. and we get this a lot. The FCC requires stations to upload information to their political files about all candidate ads and only those issue ads that communicate message relating to a political matter of national importance. We don't require any particular kind of form. Now, the NAB form is a form, of course, that the NAB provides as a convenience, and stations certainly can use that, but stations can use any form they want to upload the information. What's important is that someone going to the political files, a member of the press, a member of the public, a scholar who's researching something, that the information is available to them when they go to the political file. The form that the information takes is up to the station.
Okay, great. Let's see. I am often asked to share the commercial for an opponent. Am I required to do this?
The actual
sorry.
text of the commercial, no.
Okay.
Let's see.
Let's see. So may we request copies of the slides from FHH or from our state association? Yes, you may, and they will be made available. Can we tell an opponent how much the other candidate bought in radio ads? This is one where not that they're being asked for it, but can they volunteer it?
That's in a way, that's a head scratcher.
To me, that almost sounds like less of a
I would say this.
issue, and that's maybe what's in the purchase order for the commercial time, right? Is it going to be kept secret or not?
Well, you can't keep it secret because the activity of the candidate buying the time is going to be posted, hopefully, within 24 hours.
Well,
And then it's incumbent on candidates who are interested in knowing what the opposition's up to.
well, that's true. So this is really just how much did they buy?
You mean the quantity of ads?
Yeah, I think that's what it is. I think it's the quantity.
Well, that will be in the political file.
Yeah,
Candidate number one comes into the station and buys so many number of spots to air at such and such times and paid such and such amount. All that's in the political file,
right.
or it should be.
Within 24 hours, within one business day, right?
Within one business day, not 24 hours.
Right, within
So
one business
let me go back to what I think was the part of the question. If a station wants to tell competing candidates what these candidates are doing, I don't think we can prohibit that. And as I said earlier, I think it may be a good strategy to try to make sure that people are aware of the stuff. So in other words, it's not prohibited. If stations choose to do it, I've rarely heard anything about this, but they certainly have the prerogative. I mean, we can't stop them from doing it. But it could get tricky when it's being done in a partisan way. So in other words, if they're only telling Democrats, by the way, your Republican challenger just bought all of this stuff, and are you interested in joining the party? When ultimately the parties are against each other. That's an interesting question. I'm not sure we've ever had it. I'm not sure what we would do with it, but it, I mean, very partisan people who raise money for political parties can own stations. They certainly can be personalities on stations. None of that's prohibited. But this outreach to make sure that people know certain information. If I were running the station, my view of things is that they should do it in a balanced way, just like the law. They can't pick and choose who's going to get equal opportunities. And so by cherry picking, at the very least, if reporters learned about that, then the reporters could report that this station is acting in a partisan way. And that typically, in this world that we're in right now, will mean that 50% or 40% of the country, of the jurisdiction that you're in, is going to be mad at you. And that sometimes can generate viewers or listeners tuning your stations off, right? Because they think that you're being unfair. So that would be, I think that's probably the strongest way that could be controlled.
All right, we have another one here. Do we need to make all day parts available to candidates? Or can we offer a limited specific day part, such as 5 a.m. to 12 noon?
If they're state or local candidates, they can do that.
But
They
not,
can't do that with federal. They have to offer all the same things they offer commercial advertisers.
okay,
But
we have
with
a
state,
follow-up.
they don't have to sell the state at all. So we obviously couldn't help the fact that if they want to sell, they only want to sell in limited ways, and they can. And once all equal opportunities are met in the state and local race, they can stop the sale in that particular race, as long as it's state or local. But with feds, they don't have that ability.
Okay, there's a follow-up to an earlier question about the agency commissions, the percentage that's taken. And basically, I'll just read, based on the gross versus net logic for agencies, does that mean that national buys, which we essentially pay 2 agency fees on around 30, totaling around 30%, should that be grossed up accordingly as well? So therefore, should we produce 3 political rate cards, one for net, one for agency, and one for national?
That's a stumper. I'm not sure. But if the person is that a question that's on here? I haven't even looked at the chat lately. I'll certainly get that person, or make sure that person gets an answer to the question. In the past, the only thing that I can think of that sort of, I think, and it may be what the questioner is asking, sometimes the candidates who use reps to buy their time through an agency, let's say, so that's where I would know that there was a double situation. We've always attributed the rep commission, I believe, and it's been a long time since I've even thought about that, but I believe the rep firm commission is something that the candidate's responsible for, not the station. But I don't want to misspeak about that because that's a huge deal. But that's my recollection of how we dealt with this double commission situation. But in fairness to the questioner and to the general public that's listening to this, I'm going to try to confirm what my recollection is.
And I'll point out, and not to put you guys on the spot, but you guys have just been, and I mean all 3 of you, Seema, Gary, and Bobby, just extraordinarily generous in terms of, you know, making your phone numbers, your cell phone numbers, and answering. I know you've been great with us, answering questions, making yourself available during these things. So, you know, everybody's contact information is on this last slide. So I'm going to take one last question, and then that will be it for the day today. But obviously, there are many questions here we have not had an opportunity to get to. You know, please feel free to send us emails on these follow-up questions. I apologize if we have not had a chance to get to them, but I'll touch on this one just because it dovetails with something that that Bobby, you spoke about earlier about the owning of clusters of stations. So if you have a cluster of stations, can you choose to exclude a station and local advertising from certain stations, or do you need to make all available when determining lowest unit charge?
Well, if we're talking about federal candidates, they certainly have the right to buy the cluster in its entirety, but most candidates are not interested in the clusters because some of the stations are just not going to get them any traction in terms of their own campaigns. And we've had this situation where we've gotten lowest unit charge complaints where at first blush, Gary and I had one a couple of years ago. It certainly looked like they had violated lowest unit charge because there was a dealer, I think it was a tire dealer in a market, but the tire dealer was buying the entire cluster. And so the candidates were only interested in 1 or 2 of the stations in the cluster, so that cluster rate that the tire company got need not be factored into when people go below the cluster and want to buy a station or 2, then the station has their own lowest unit charge. The cluster itself insulates the stations from anyone that's buying the full cluster. but they can come to their individual stations. But again, the station doesn't have to be including what they get from that cluster or relationship, and a lot of these clusters, for the most part, as we've seen, now I've become much more aware of it lately. The clusters are typically owned by the same company.
Right.
And as I said, I mean, there's still companies out there that own 600 stations, something like that. They used to own, I think there was at one time when it was Clear Channel, they owned 1,300 stations, which was more than 10% of the commercial radio stations in the United States. So that's a whole nother issue, which
Right.
I don't mean to color, but it's just, that's the way it is.
All right, well, thank you very much. We are out of time. And again, I want to apologize if we did not get to your questions. You have everybody's contact information there. So this is a good opportunity to do a screenshot of that right now, if you haven't done it. The slides will be made available through the state associations. We hope to have this actual webinar. It's being taped and make it available on our Fletcher Hildon Hildreth's YouTube page, as well as on comlawblog.com in the very near future, as well as through the state broadcast associations. And again, I want to thank all the state broadcast associations that were involved in helping them put this together. Many of you are going to be in Washington for the State Leadership Conference. If you see us during State Leadership, please come up, say hello. We'd love to meet you guys. And last but not least, I want to thank our very distinguished guests for participating here. Seema Nielsen, Gary Schoenman, and Bobby Baker. You guys are absolutely great. I cannot say enough about how generous you are with your time to be able to answer these questions. And it's always a joy getting together with you. And I hope this is not the last one of these that we do. But for now, that's all for today. Thank you for tuning in, and have a great rest of the day, whatever time zone you may be. Goodbye.